From the opinion pages of the Wall Street Journal, this is Potomac Watch.
In a 6-3 decision, the Supreme Court rejects a challenge to government jawboning of social media sites like Facebook and Twitter to take down or moderate more content. Plus, President Biden's latest student loan forgiveness loses in federal court before two judges appointed by President Obama. Welcome, I'm Kyle Peterson with the Wall Street Journal. We are joined today by my colleagues, columnists Alicia Finley and Kim Strassel. The Supreme Court is almost to its summer finish line, though there are still some big cases outstanding, but one fewer as of about 10 a.m. this morning. That's when the justices dropped their opinions in Murphy v. Missouri. This is the case on the federal government's coordination with social media sites, largely during the COVID pandemic. Alicia, it is a 6-3 decision, but not the 6-3 that listeners are probably imagining. A majority opinion is written by Justice Amy Coney Barrett, joined by the Chief Justice and Brett Kavanaugh, plus the three liberals, and then a dissent by Justice Samuel Alito, joined by Justices Clarence Thomas and Neil Gorsuch. Alicia, give us a sense of what the majority said here.
So the ruling was narrow and it was on the grounds of standing. And if you recall, this came up just recently with the case that involved the FDA and the abortion pill mifepristone. And standing is a very core principle, and it requires that plaintiffs to bring cases in federal court must have suffered or show that they have suffered a concrete injury that is fairly traceable to defendant's conduct and can be redressed by courts. Now, again, this is a core principle to ensure that federal courts only hear cases and controversies so that they're basically not just a moot court, so to speak. And here, the 6-3 majority held that the plaintiffs did not prove their burden and did not show that they either, in some cases, that they had suffered a concrete injury. In most of the cases, the plaintiffs, which included some scientists as well as two states and individuals, they couldn't show that their injuries, which in this case would be suppressed speech, being deplatformed or having their post removed or demonetized or in other ways censored, that those were actions that the platforms, in this particular Facebook, took were actually a result of the government's pressure campaign. So what the 6 justices essentially said is, yeah, they may have their content or their posts may have been suppressed, but we can't determine with any kind of a clear link if that was actually the result of this pressure campaign by the government officials in various agencies. And it's not really clear that we can address it going forward because it seems to us, at least, that the government officials, the Biden officials who are doing this have backed off and they're no longer doing it. So we can't really issue an injunction against something that's no longer happening. At least that's what the 6 justices in the majority said. The dissent, Justice Samuel Alito, joined by Clarence Thomas and Neil Gorsuch, had a different view. At least they believe that at least one of the plaintiffs, the individual, had standing to sue. And as long as there's one, they should address the merits of the case. And they thought there was a link, even though if it wasn't quote unquote ironclad, between the government's pressure campaign and the jawboning and the actions that the third parties, in this case, the social media platforms, took to demonetize or suppress the content of this particular lady's post about COVID vaccines. So there's a back and forth actually in the footnotes of the decision between the dissent and the majority. And what I found most amusing is the majority basically says, well, the dissent, you actually make a stronger argument than the plaintiffs make. You're drawing lines and connections that the plaintiffs didn't. They may be correct, but the plaintiffs didn't actually do that, and you guys can't fill it in for them.
Here's a piece of the majority opinion by Justice Amy Coney Barrett. She says the platforms moderated similar content long before any of the government defendants engaged in the challenged conduct. In fact, the platforms acting independently had strengthened their pre-existing content moderation policies before the government defendants got involved. For instance, Facebook announced an expansion of its COVID-19 misinformation policies in early February 2021, before the White House officials began communicating with the platform, and the platforms continued to exercise their independent judgment even after the communications with the defendants began. For example, on several occasions, various platforms explained that White House officials had flagged content that did not violate company policy. And Kim, I have some sympathy for that. The difficulty with this case, in my view, was always that it swept in an enormous range of conduct, including stuff that looked pretty good faith and pretty innocuous to me, like company staff at these websites asking the CDC for clarification on, do you have any information about whether this claim about a COVID vaccine is true or not? And some of them were pretty wild claims, such as that taking a COVID vaccine could change your blood color or could cause magnetism. And so alongside, I think what are more concerning communications was a lot of very innocuous stuff. The majority opinion goes through some of specific examples. Some of the plaintiffs, for example, are complaining about restrictions imposed on them by the social site LinkedIn. And then they say there's nothing in the record about White House officials communicating with LinkedIn. They say that some of the complaints about content moderation happened before any of the communications between these social sites and White House officials in the record. On the other hand, some of the communications that have come out as a result of this litigation, I think, are more concerning. And the dissent really zeroes in on some of these, for example, emails from Rob Flaherty, the White House Director of Digital Strategy, emailing Facebook saying things like, you're hiding the ball. He's gravely concerned that Facebook is a top driver of vaccine hesitancy. We want to know that you're trying. We want to know how we can help. We want to know that you're not playing a shell game with us. And Kim, honestly, I expected a stronger statement from the court that some of this stuff is over the line.
Yeah, I think when we step back and we look at this suit, it goes to Alicia's point about the footnotes, that the weakness of this case, it isn't that it's a very serious topic. It is. And there are, as you note, some very grave concerns that were highlighted here, actions by officials that I think are just obvious, clear no-nos. But the suit was in a way so messy and so all-encompassing and throwing in so much chaff along with the wheat that it just gave the majority, who seemed to want to, let's be clear, they ducked this issue. It gave them more than enough ammunition to do so. And that is what the most of the majority opinion is going through and picking up these easy ways of saying you don't have standing here, you don't have standing there. I think the reason that I really like the dissent is that it separates the wheat from the chaff. In particular, they focus in on one plaintiff, Jill Hines, who's a healthcare activist, and make the argument that her case alone does fulfill the different pieces that you need to bring a lawsuit and have standing. They argue that she was still being censored as she sued the government, so injury on its face. They argued that she had clear traceability, could trace a connection in certain instances where she was censored as a result of government pressure on social media organizations, and that she also showed that the threat could be redressed by an injunctive relief, which is meaning the court coming in and doing something. So they argued very much that she had standing. And there was one note in the dissent, too, almost a little bit of bitterness or pointed, sharp commentary by Justice Alito about that Mifeprestone case, in which all of the justices had agreed on a 9-0 basis that the plaintiffs lacked standing. And obviously that was on a huge issue, abortion. And what Justice Alito said is standing is cheapened when the rules are not even-handedly applied. And so that did seem to be the minority suggesting that in this case, because the court did not want to deal with this big, huge issue of how you handle censorship when it comes to third parties, in particular social media outfits, that it was not actually dealing with standing in a way that the court would otherwise in a case that it wanted to handle, basically accusing them of using the standing as a way to wiggle out of having to handle this big case. The other thing I really loved about the dissent is it talked about just how serious some of these things were. Like you said, Kyle, about this was a case that fundamentally ended up denying to health officials and states the ability to share their expertise with residents. that it was aimed at very distinguished professors, and that it, most importantly, was aimed at the kind of speech that we consider most important, speech that helps us inform questions of self-governance and speech that is engaged in advancing knowledge, and said that as a result of that, the argument was the court really needed to have looked at this more closely and not have ducked the issue.
Hang tight. We'll be right back in a moment. Welcome back. Alicia, is one risk of this ruling dismissing this challenge on standing grounds that government officials in these agencies in the White House might decide that if they do this kind of jawboning of social media organizations, they might be able to ultimately get away with it? And what is the standard, do you think, that the Supreme Court is now going to use to police this kind of thing? Because it's worth noting that late last month, there was another decision by the Supreme Court on a similar issue. This was the case NRA v. Vullo, and it was a unanimous Supreme Court there, Justice Sonia Sotomayor ruling in favor of the NRA, which I did not have on my 2024 Supreme Court bingo card. What are the differences between the jawboning that took place in that case and the jawboning that was dismissed today?
So in that case, if you recall, that involved the former New York the superintendent who oversees all the financial institutions in New York, banks, insurance companies. And there was a very clear link between her threats against these companies to pull the insurance policies or the NRA and other gun advocacy groups and their actions. She used her authority over them, threats, and in response, they actually directly took actions and did rescind the NRA policies. Now, the Supreme Court ruled 9-0. And again, this wasn't actually on the merits. It was just whether the case could proceed in the lower courts. And the justices ruled 9-0 that the NRA made a plausible argument in that case. And it reviewed that under the Bantam Books precedent, which the dissent in this case, in the Murphy v. Missouri case, alludes to several times. And under this standard, whether the government can be held responsible for the private actions of third parties, standard is whether the government officials exercises a substantial amount of authority. And the courts are also supposed to look to the tone of the speech or the tone of the threats or the demands, as well as how private parties respond to it. And if you read Justice Alito's dissent, he clearly believes under the Bantam Books precedent that the White House officials, at least in this case, Flaherty and Slavitt, crossed the line and should be liable, and that they were actually acting and did violate the First Amendment rights of Hines. But I would also argue, I've heard argued, that they are also violating the First Amendment rights of the platforms to actually moderate their own speech. And I think the dissent, again, lays out that Bantam Books precedent should control in these kinds of cases. And it's unfortunate that the majority here really ducked and dodged because, to your point, I think really does give a license to other government officials. You could see a future Trump presidency and Trump officials trying to jawbone platforms about maybe how they're moderating content about immigration or all kinds of things, or to remove certain posts or suppress certain posts they don't like. And none of this would ever become public, by the way. The only reason some of this case became public was first because the congressional investigation, which actually ended up prompting a lawsuit and demands for discovery. But most of the time, this kind of jawboning and pressure campaign will completely occur in the shadows, which is something that the dissent is really suggests that it's really concerned about.
Kim, what's your take on this risk, and what do you make of the potential for another reaction to the Supreme Court ruling, which would be something like the bill that Josh Hawley, Senator Missouri, proposed several years ago to say if the Supreme Court is not going to take on this jawboning, then Congress has to do it. The Hawley bill that he proposed would have required social media sites, big internet sites, to get a certificate from the Federal Trade Commission in order to keep their Section 230 immunity. They'd have to show the FTC that they do not moderate content in a manner manner that is biased against a political party, political candidate, or political viewpoint. And to my mind, that would be a mistake, in part because it's not clear what those terms in that legislation would even mean. What is a political viewpoint? Does that count Islamism and white separatism? And the idea that you would have a government agent giving these social sites some kind of certification for their content moderation policies, I'm not sure that we want to go down that road, though in the wake of this Supreme Court ruling, Kim, I suspect that there may be some demand by critics of social media to do that.
Well, to Alicia's point about the sophistication of this, and the dissent does really hone in on this and talk about the Vullo case that you mentioned, and note that the difference between these two cases is mostly one of subtlety. There's actually a line that says what's happening here is simply more subtle than the ham-handed approach that Vullo used. And it warns very precisely about the risk of just closing your eyes to that sophistication and subtlety. There's a line in here. It says, if a coercive campaign is carried out with enough sophistication, it may get by. That is not a message this court should send. So, I know it's very clear that the dissent had very much drawn a bead on the distinctions between those two cases, but arguing very much that just because government was a little bit cleverer in this case, that the court still had a duty to intervene. To your point about Congress and social media companies, that was the other fascinating part of the dissent, is that Alito goes out of his way to note that we're not talking about just any organizations here. We're not talking about news organizations, which have their own protections. And it is notable that government in this case was not calling the New York Times or the Wall Street Journal, so far as we know, and attempting to dictate to them what could or couldn't be written. But they were going after social media companies. And Alito notes that these organizations are becoming the leading source of news and may continue to grow. And also notes that while these social platforms are rich and powerful, they are also more vulnerable than media companies because they are at the mercy of the Communications Decency Act. They are at the mercy of potential antitrust actions by the government. They are dependent on the U.S. government for certain diplomatic efforts so that they can try to avoid EU or European Union regulations or antitrust actions as well. And he points out that that all makes this particular group of industry players and news providers, social media companies, a very powerful incentive to dance to the government's tune, all of which was an argument for why the court ought to intervene. Now, it didn't, as you note. And the risk here is that Congress does step in, and maybe Congress needs to do something anyway. We've had a lot of discussions about social media companies and the Communications Decency Act and how all that interplay works. I think the Hawley bill, though, is one of the worst impulses of trying to set up a new mechanism in which government is making these decisions. I'm not quite sure how that solves any problems. It's more a case of Congress attempting to look like it's doing something, but potentially doing something that makes the issue worse.